This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law. I'm Josh Block. A new way to watch live broadcast TV was launched 2 weeks ago. It's called Aereo.
Now there's Aereo, a new platform for bringing live broadcast TV to the internet, wherever and whenever we want it.
Banker Porter Bibbs calls the service a technological marvel. Law professor Tim Wu calls it a bit of a headspin. What it does is allows you to watch and record live television on your computer or mobile device, and at $12 a month, it could create a cord-cutting threat to cable and satellite providers. First, it will have to survive a legal challenge. Within weeks of being announced, Aereo was hit with a copyright infringement lawsuit brought by television broadcasters. I'm joined now by Bloomberg BNA legal editor Amy Bivens. Amy, tell me about Aereo. How does the service work?
The Aereo service, which launched in New York City in the middle of March, it works by transmitting broadcast over-the-air signals of TV programming in the New York area to subscribers' internet connection. So they have many antennas grouped together that capture the broadcast signals, and it's routed through the Aereo system into subscribers, get it on their laptop, on their computer, on their iPhone, iPad, I think any electronic device that's connected to the internet.
So subscribers get all of the free over-the-air TV content that they would receive if they had only a TV with an antenna at home?
Right, yeah, and it's the same content that they can also get on cable, but for the service, it's specifically limited to just the content that's free over-the-air broadcast content.
The service is currently only available in New York, but there are plans to roll it out to other cities. But since it's only in New York, the plaintiffs in the case we're going to discuss are only the New York broadcasters? There's
a wide variety of plaintiffs. It's basically all the major media companies. It's ABC, Disney, CBS, NBC, Fox, PBS, and right now it looks like they're focusing on New York content, but obviously, a lot of these broadcasters broadcast elsewhere as well.
The lead investor, Barry Diller, has emphasized that each antenna, this is a quote, essentially has a consumer's name on it. What is the importance of the individual dime-size antenna farm that, and I think it's somewhere in Brooklyn, that provides an antenna for each user? Because this certainly seems inefficient technologically and maybe technologically unnecessary, but it may be required for the service to be legal?
Right, yeah. The argument is that because each antenna is assigned to a specific subscriber, that the transmission is private. So their contention is that this isn't a transmission to the public because it's no different than a consumer using an antenna on their apartment building or rabbit ears to collect a signal. It's just in a more convenient location, routing the signal to their internet connection.
The infringement occurs, it's not the antenna bringing it down, it's then when they, I don't know if they're using transmission or what they're technically, but it's when it's sent over the internet to the user?
From my understanding of the filings, what the plaintiffs are concerned about is they're saying that when they're transmitting this content to the subscribers, they're infringing their performance rights. So when it's going through their system, they're in effect retransmitting or performing this content, and they don't have a license, and so they complain that it's infringing their performance copyright.
Does it seem that this will come down to whether or not the court believes this is a public or private performance?
It could. I mean, that's definitely, based on the court filings, it seems like that's going to be a big issue in this litigation. They're probably going to be arguing about some of the other points as well. So there have been several streaming-related decisions that have come down related to the theory that an internet subscriber is renting content. So the litigation could also focus on that as well. But it looks like at this point, the transmission issue, the private issue, is going to be a really big issue in this litigation.
Why does Aereo believe that their service is legally sound?
They make three main arguments why they think their service is legal. They say that it's private because each consumer or subscriber has this antenna, this mini antenna. But they make a couple of other arguments as well. They say that under the Sony Betamax case and the Cartoon Network Cablevision cases, that consumers have a right to make copies for personal use, and they can play back those recordings, and that's not infringing.
This is a big threat to cable companies. Their subscribers could potentially cut the cord, but it isn't the cable companies that are bringing the lawsuit. It's the broadcasters. What do you think the broadcaster's concern is? That is, there are now more eyeballs for their advertisers. One would think on that level that a new innovative way to get more people watching TV is a good thing for broadcasters. So do broadcasters want to kill this service altogether, bring in licensing revenue for their content, or something else?
I mean, I think it's hard to say. At this point, Aereo isn't paying a license fee at all, so that's definitely one of their concerns. It seems that the broadcast companies see it as a threat to losing their licensing revenue from cable, and also if they want to license it through other online services that may come besides this free service that Aereo is offering, or free in the sense that they're not paying the broadcasters a licensing fee.
If it did turn out that this is deemed a public performance, a retransmission license for Aereo could solve the problem.
The retransmission issue is a touchy issue, too, and it's not directly touched on in these filings, but there's another pending case that's in the Second Circuit right now. It's WPIX v. IBI. And that case is interesting because it is exploring whether Internet streaming is potentially able to get a license to stream content. And the lower court in that case held that the Internet service, because it doesn't fall under FCC regulation, which is a whole different issue, the service wasn't entitled to get a license. So that case could also potentially have an impact here.
Tell me about Zediva case and what happened in that case. What was Zediva's service, and could it affect what happens here?
It was a different business concept, but it also came back to this idea of a rental. An individual was renting access to content. So the Zediva case, what happened was there was this online service, and at least based on the court filings, what they were doing is they were allowing consumers to go online and rent access to a DVD. I think they charged $1 or $2 to access. And so instead of going to a DVD rental store or renting one on Netflix, what they could do is just go online, rent it, and they would have individual DVD players, and they would just hit play. And when a consumer requested access to a DVD, they would hit play, they could see it, and they were arguing that this was just a rental, it wasn't a performance. But in that case, when the filings came, or when the ruling came on the plaintiff's motion for an injunction, the court wasn't persuaded that this was a rental. The court felt that it was at least likely that the plaintiffs were going to prevail on their argument that this was an infringement of their performance rights. So the theme of an individual renting access came up in that case as well.
That was in a different circuit.
That was in the Central District of California, and that case has been settled.
There is a Second Circuit case as well, the Cablevision DVR case.
And it's actually cited pretty extensively in the filings in this case, dealt with a remote DVR service. The court held that the remote DVR service didn't infringe the reproduction right because the consumers controlled when the content was copied and played back. And the plaintiffs in this case contend that the Cablevision case has no real bearing here because what these plaintiffs are concerned about and what they're complaining about is the performance right, which they contend is completely separate from the reproduction right that was at issue in the Cablevision case.
Aereo, I believe, is up and running. I've seen some reviews. People really like the service. Where are we with the case?
The initiation of the litigation, there were 2 lawsuits, but it appears that the cases have been consolidated. Aereo has filed its answer and counterclaim. It wants a judgment that it does not infringe the copyrights of the plaintiffs in this case, but at this point, the plaintiffs have requested a preliminary injunction, and the court has scheduled, I believe, a hearing in May on that motion. So at this point, it appears that the service will be up and running at least until the court rules on that.
I've seen a lot of legal commentary about it. Experts seem to disagree about whether Aereo will be ordered to shut down its service based on these prior court decisions that we just talked about. When you read these court decisions and where we are in this court now, do you have any sense of how the court might rule?
It's really difficult to say at this point. Aereo has some very creative and interesting arguments about the private transmissions. You know, I mean, they've gotten these many antennas. At least based on how they say the service works, it doesn't appear to be any different than a consumer putting an antenna on their apartment or putting rabbit ears on their TV. But on the other side of it, the content owners are very concerned and feel that the service is not comparable to this because it's a centralized system. You know, they're charging for the service, and they contend that this may be built to look like it fits into this exception or this right to receive over-the-air content, but it doesn't. That in reality, when you boil it down, what it is that they're transmitting their content without a license, and that infringes their right to perform their work.
Is there doubt that the service works the way that they say it works?
I don't know.
The reason I say that is because, you know, I think in your article, and it may have been the language of the complaint, but it says purported, and even now you said, you know, the way that they say their service works.
Yeah, well, and there's definitely in the filings some skepticism, I think. I mean, the plaintiffs refer to it as gimmickry, and they're saying that, there are all these little antennas that they have in various places, but the plaintiffs say it boils down to that it doesn't make a difference whether it works that way or not. It's, if they have one big dish or one little tiny antenna for every subscriber, that the legal analysis doesn't really turn on that.
That's Bloomberg BNA's Amy Bivens. For more information about this and other topics, subscribe to BloombergLaw.com. You can find our recent programs on our YouTube channel, follow our daily updates on Twitter. Thank you for listening.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.